we have a presentation for you all today. I'll introduce our other panelists in just a moment here. So we will pull up that presentation and go through that, and then we'll have a Q&A period where we would love to hear from you all. There we go. Fantastic. All right. So again, I'll introduce folks. We will go through what you are here to learn about how to respond to this new IFR ruling, and then again that Q&A period at the end, which will give you some instructions for how to participate there. A couple of notes, a couple of housekeeping things before we get into things. This session is being recorded and it will be posted to YouTube afterwards. We will be distributing that link. So I'll talk a little bit more about that at the end when we talk about next steps. We will encourage your questions and comments, and we'll have some dedicated time at the end. We're trying to get about half of this session dedicated to that. We've got some of the ruling to get through first, and then we'll have that open period for you to ask questions. We'll give you some more instructions once we're closer to that time on how. I am Dr. Nicole Yates. I will be moderating the questions, and I'm a senior consultant at Keen Independent Research. And so we have our two panelists here today that I will introduce. You are going to hear from them momentarily. So first off, Dave Keen is a principal and founder of Keen Independent, a national economic and policy research firm. He has helped state DOTs, transit agencies, and airports across the country implement the federal DBE program, including conducting availability and disparity studies, setting overall goals, and preparing program plans. He has also authored the Transportation Research Board studies to enhance the effectiveness of the DBE program. He served as an expert witness in the successful defense of contract equity programs, including having worked with Mara Rosales to defend the California Department of Transportation's program. So that's Dave. And then we have Mara Rosales, managing partner of Rosales Law Partners. Prior to entering private practice, Mara served as San Francisco International Airport's general counsel for over a decade, and for 9 years as the San Francisco Deputy City Attorney in the Government Law Division. Mara's distinguished career includes experience in airport law, government law, and specialized area of equal protection law in public contracting policies. Mara authored and defended several business contracting programs in the Ninth Circuit, including the original San Francisco Minority Women Local Business Enterprise Ordinance. She was lead outside counsel, successfully representing the California Department of Transportation, Caltrans, in the Associated General Contractors versus Caltrans matter and action challenging the constitutionality of California's 49 CFR Part 26 DBE program. So you will hear from them right now. I will pass this over to them to get started here.
Well, thank you very much, Nikki. And Mara, we're ready to summarize 4 decades of development of the federal DBE program and the latest IFR, all in about 15 minutes so we can get to questions. You ready? Okay.
I'm ready.
All right. So I don't know where everybody was on October 3rd. I think it was on October 1st that I got an advance copy of this, and I was coming from Kennedy Airport to a place we were staying in Long Island and read it in the Uber. Mara, I think you were in New York too, but everybody on this call has looked at this and probably knows where they were when this was a bit of a surprise. And Mara will probably have some comments about the fact that it's a bit unusual. We got FAQs. They were dated October 24th. And then we have a question mark. This isn't the first and only question mark. This is the first, but not the only question mark you'll see in our presentation, because we don't know. There's some anticipation that because USDOT asked for questions, or ask for comments on the interim final rule, and it does have the word interim in it, that there will be something in the future. But we don't know, and there's a number of immediate requirements. So the IFR was immediately effective. You all had to immediately take some actions. By the way, this is the caveats here is this is a webinar really focused on those that are implementing the program or certifying DBEs or both. So if we have some DBEs on the call today, I think this will be interesting, and we really want to get your questions. But we've really steered this towards what do you do if you're, an employee, a leader implementing the program right now, and you suddenly get this IFR. Um, and we only know what we know today. So, we could put the November 19th date in there. We're certainly learning things every day about what people are doing around the country. We're not necessarily learning things from USDOT because everybody, well, first of all, staff were furloughed, and the staff that might have been dealing directly with state DOT or a transit agency or an airport or a certifier might not know anything anyway. Mara, you want to fill any of, you have anything more to add here?
Thanks, Dave. Good morning from San Francisco, everyone. So the only comment that I would make here is one that you alluded to, which is that this is an unusual rulemaking process. When I was at SFO, I started in, wow, I'm dating myself, 1992. I've gone through many rulemaking processes with appropriate, comment periods, et cetera. And this one, frankly, I've never seen before. And it's unusual in the sense that besides the fact that it's interim, that it's effective immediately, and then the comment period is subsequent to the implementation of an interim rule that by definition could mean could change. So this, in my opinion, frankly, this is a process that leads to potential chaos, as I'm sure many of you are feeling, and uncertainty. And since I'd like to speak frankly, anyone who knows me, I'm not sure that the justification that's in the rules itself for the immediate action, if you will, or the urgency is necessarily warranted or in the public interest. But it is what it is, and we have to work with it. And so here we are.
And the other caveat is there may be attendees who would like 10 minutes of hand wringing and griping about what this does and what the intent behind it is and how this flows out of the Mid-America Milling case. We're there with you, but we don't have the time to do that today, and it's probably not the focus of what you need from us. So we're not going to do any of that. It is what it is, and we think we have enough information now to move forward on what everyone needs to do. As of the information we've received today, that's what the next slides are going to be, including the next one, which has the same dates, similar dates, and you had to immediately scramble, and we assume those from direct recipients have done this, that you are immediately to stop setting DBE contract goals going forward, dealing with contracts that were in various stages of being awarded or advertised on past contracts, stop counting DBE participation and stop doing cuff reviews because that's really a part of the counting process. But continuing the substitution protections for DBE subs on current contracts, and that was made clear again in the Q&A that came out a few weeks ago. Certainly continue neutral measures in the DBE program. Stop certifying until you have the new procedures in place. And then those are things that should have been done pretty close to October 3rd. Different states are in different stages of notifying DBEs and preparing for recertification. So that's the kind of October, that might be November for some states. It might still be in the future for some states. So we're not going to talk a whole lot about that. Those kind of two boxes here, we're really going to talk about what do you need to do if you are interested in restarting DBE contract goals on a timely basis. How would you make that happen, and what needs to be done before that happens? And we have, as soon as practicable, comes out of the IFR, reevaluating certification of DBEs in the home state, so the state in which those DBEs were originally certified. By the way, we're talking DBEs and ACDBEs all the way through here. We just didn't have space in the boxes to put in ACDBE, but the requirements are the same. So that needs to be done, and the UCP in each state needs to inform USDOT when that's complete. That's not the only thing that needs to happen, however, because each direct recipient that meets the thresholds to have the program needs to submit a new overall DBE goal, and that will include a projection of what's instead of race and gender conscious, race and gender neutral. That will now include a projection of DBE neutral and whatever it can't be met through DBE neutral means. Those are the formerly race and gender neutral means like small business efforts and technical assistance and other things. That will, what you can't meet in the overall DBE goal will need to be met through DBE contract goals, which are still allowable under the program. It's just the definition of who is a DBE is changing. And you will need to submit a new DBE program plan. So all three of those things need to happen, and you cannot go to restarting DBE contract goals until those three things have happened. So moving off to the right, continue to review new applications. It's not just the reevaluation process, although that is a focus right now. And once you are ready to restart the program, some entities will only have neutral efforts, and those will start recounting DBE participation, doing cuff reviews and other things at that point. Um, Others may be restarting the DBE contract goals, depending on what the overall goal is, the overall DBE or ACDBE goal is, and if when you do the projections, there's a need for the DBE contract goals or the DBE conscious measures to be able to meet the overall goal. So we have October 3rd. Hopefully everybody has successfully done everything that's in there and then some other things. Hopefully everybody's notifying DBEs, preparing for recertification. And then what we really want to focus on the rest of our slides are what's in the boxes under as soon as practicable. What do you need to do to get to the right-hand box? Mara, anything that I should have said that I forgot?
No, I think we're going to get into the weeds on some of this moving forward. So let's move on.
And we're going to take from our point of view, the most uncertain, the most where there's some subjectivity of how you even interpret the IFR. We're going to take that first, which is the first thing in the as soon as practicable box, which is reevaluating the certification of DBEs. Okay, so this is what's in the IFR. You need to give the opportunity all currently certified DBEs in the home state to recertify. That would certainly require notification of those firms, some information going to those firms. And we take the stance that there's an expectation from USDOT that is beyond just information, that there will be some assistance for currently certified DBEs and ACDBEs. There has been some confusion, at least among DBEs that we've spoken with, about what you do in your home state and what you do in other states where where you have certification, because some states have been giving letters out just decertifying DBEs in other states and not in their home state. A better way to explain that, and maybe that's in the fine print, is until you reapply in your home state and you're recertified in your home state, and then contact the other states, that certification in that secondary state is no longer valid. The recertification process applies to DBEs in in the state in which they were, the home state, the state in which they were originally certified, or is their home state now. And not all of those DBEs presumably will make it through the process, or not all of those DBEs will submit an application or submit the information for recertification. And then in that case, at some point, those DBEs will no longer be certified. They can still apply for certification in the future. That does not prohibit them from doing that, but at some point, to be able to be inform USDOT that the reevaluation is complete, some will make it in and some will not make it, either because their applications are insufficient or because they simply do not provide any information or are not interested in continuing certification. Once that's done, notifying USDOT when it's complete. And USDOT reserves the right to come back and look at it, but there's no, our reading the IFR, there's no formal letter you're going to get from USDOT saying, oh, yeah, we think what you've done is fine. You just simply notify them. And then at that point, it seems that the interstate applications of DBEs that have been approved in other home states might be coming in. But you do not need to have all of those, is one reading of the IFR to be able to notify USDOT that you have completed what you are required to do. Again, Maura, what additional comments will you have on this? And then we're going to get into the complexities of what it means to be completed a personal narrative and show social and economic disadvantage.
Yeah, so the only comment that I would make, two quick comments. The word decertify, basically, as an attorney, it's a word of art, and it's not actual decertification here. It's technically a suspension of the current certifications for DBEs and ACDBEs because under the prior rule, DBEs and ACDBEs had rebuttable presumption of disadvantage. So it's a suspension and then requiring a reassessment essentially. And so obviously this is going to cause a lot of confusion and a lot of consternation among DBEs and ACDBEs. And so just to drive home the point that UCPs historically have and are expected to assist kind of navigating the process, and that is more on the procedural compliance, if you will, rather than, obviously we'll get into the personal narrative requirements, but there's no coaching obviously on how to comply that is allowed, but procedural compliance assistance is definitely something that UCPs are going to be have to engage in, I think, just to make things more seamless.
Okay, so how do you explain social disadvantage in a personal narrative? This comes out of the IFR. We treat this as 4 topics or 3 topics plus because it's education, employment, and business, including obtaining financing. So you see those listed there. And it's not just, oh, I was treated differently from others and experienced social disadvantage in education. Then the second big bullet there is the so what. So what harm did that cause you? Can you tie that to how it affected your ability to get into business or grow your business, sustain your business? And can you say anything about the words out of the IFR? Type and magnitude. Our shorthand for that is, so what? So, you were denied a business loan. Do you think you were treated differently and why? And did that have a negative effect? You need to spell that out. One way, and our team, and we'll explain why we're so deep into this, one of the ways that we think about this is if it's not on the page, if you haven't spelled it out as a DBE in your personal narrative, or if you're a certifier and you're trying to review this, if it's not on the page, if it's not spelled out, if you don't, the DBE should not be making the assumption that you can fill in the blanks. It needs to be there. That what's on the page in the personal narrative is what's being evaluated to see if there is sufficient evidence of social disadvantage and linking that to a negative impact on the business owner and his or her firm. Um, you need to explain how that experience differed from similarly situated non-disadvantaged persons. For example, if you were denied a business loan, lots of people are denied business loans. How do you think you were treated differently from others? Are you in a different situation? Can you tell a story about somebody else got a loan who was similarly situated and you did not? And then the last bullet is it's not just the personal narrative, which is uh, what you'll be seeing a lot of that will be new in volume. It's not new in concept because white male-owned firms could apply for DBEs or ACDBE certification in the past and go through this type of process. So those were just very rarely seen in our experience around the country. It might have been, one or maybe two firms in a DBE or ACDBE directory that might have been gone through that process without the rebuttable presumption that you get with race or gender under the pre-October 3rd situation. Um, so let me go through the next couple slides and then open it up and have Mara give more explanation about this. Um, we immediately saw this as an issue and a problem for DBEs and our clients that were certifiers or operators of the program. So we worked with one of our clients to work to add a component to a current study that we were doing where it fit with that study to conduct a pilot of how DBEs might be assisted with the personal narratives. We randomly selected 10 DBEs that were certified by this particular agency. And as part of disparity studies, and our team has done 200-ish of disparity studies over the last 3.5 decades. We do a lot of in-depth interviews, and we know how those go. And so we have a lot of practice about how somebody who really isn't necessarily thinking about how they may have been affected and treated differently, how you can structure an interview or a listening session where some of those experiences they might be able to explain those when they would originally say, no, I'm treated the way as everybody else. And then you get into it and they say, well, actually not. So we structured this pilot. We went through the IFR topics. Basically, we were trying to solve the blank page problem of a DBE facing just nothing with very little information about what they need to do. And we knew that they could tell the story, but we knew that it would be very difficult for anybody to write the story from scratch, especially when it's about yourself. So we had 1 hour listening sessions. We went through the topics. They told their story, and we were able to put that story on paper. And we had a follow-up session where we went over the written document that was really the summary of what they had told us, going through each one of the topics from their perspective of going, from education, employment, being in business, starting the business, sustaining the business, and a focus on access to capital. So we had a second session with them, and then we delivered their summary to them. So the feedback we got, and this is the reason we were doing the pilot, is to not only test this concept, but also get the feedback. We found that DBEs in October were very unaware and had very limited understanding of the changes that were caused by the IFR. They really did not know what they were supposed to do. We don't think that's largely changed in most states. They did agree that there was the blank page problem. They didn't even know how to get started, but in each case, they were able to verbally describe instances in which they had experienced social disadvantage in some detail and giving some support for how they might have been treated differently, how their circumstances were different, and most importantly, the effect of that. How does that matter? The so what? They also told us that they would probably not have prepared a personal narrative without this assistance from us. Now, our client is a certifier. The client was not involved in the process, and they don't know who we assisted. So there was some distance between those making the certification decisions and when we were, and by assistance, I mean basically listening and writing things down and asking not only the kind of the basic questions, but also follow-up questions that a certifier might be interested in knowing the answer to, especially after we had it written and we showed them the document again. We had questions where we wanted to know more detail, more specificity about why they may have wanted to, why they may have been treated differently. And this, the quote on the bottom is just one of those quotes. So, in some cases, people talked about coming from poverty or coming from a household in which they didn't have the opportunities for education or didn't have the networks to have the good first jobs to be able to be later successful. And in other cases, or in addition to that, we had some people that said, "Hey, this happened in my life. I was in a different situation because I had to care for a family member when others might not have been expected to do that. And that put me at a social disadvantage and put me back, hurt the development of my company or hurt my personal professional development." And in some cases, that fell on women, and they were able to describe how that their experience might have been different from others that they are competing against now. In some cases, and this was across each one of the topic areas, they were treated differently because they looked and sounded different than other peers. They might be a person of color. They might be a woman in a field in which that's not traditional. There was some certain stereotyping that they could describe, and we wrote that down. And our position is they did not say, and they brought it up. They didn't say, "Oh, I'm socially disadvantaged because I'm a woman or I'm a person of color." They said, "This experience happened to me. I was treated differently. I think the reason I was treated differently was because of my race or gender." And we think that is acceptable or could be acceptable because it explained an event that happened to them and they were describing the cause of why they were treated differently rather than, hey, take it on face that, hey, as a person of color or as a woman, I am treated, that would be the reason to certify me. When we've talked with other agencies that we've worked with in the past that had these types of certification programs, Keen Independent did a disparity study for the city of New Orleans, for example, and other entities in Louisiana, which has a constitutional prohibition against minority and women business certification and preference. So there's a history of certifying firms based on social and economic disadvantage in New Orleans, for example. That process is very similar to the process that we followed that had been successful. So an applicant to the city of New Orleans for their local program that said, "I'm a woman or I'm a person of color, I need to be certified," would have been rejected. And an application that said, "I face these social disadvantages," that might include instances of race or gender discrimination of the cause of that social disadvantage, would have been accepted by the city of New Orleans and been within the outline of their state constitution. That's a whole lot, and I'm sure everybody has been in lots of discussions since October 3rd about this. Let me be ready to submit your questions. Mara, this has been the most difficult part of this to get our arms around. What advice do you have for those people on the call?
So thank you, Dave, for that explanation and that background. It's spot on. I can tell you and tell the attendees that I've been asked both by certifiers, grant recipients, obviously, and I also represent ACDBE and DBE clients. And so we've been asked, at least on one occasion, to assist in preparing a personal narrative. So we, as attorneys, obviously look at the IFR, but in my opinion, it's beyond the IFR in terms of guidance. The guidance, and I can share that. And if people are interested in the specifics, I can send that by separate email. But the first guidance is the Harvard, the University of North Carolina, and the Harvard case that was decided in 2023 by the United States Supreme Court. That's cited in the IFR. We can talk about the applicability of that case to a DBE program if you'd like. But really, what I tell people is that notwithstanding what people think or believe the United States Supreme Court said, they were very clear that putting aside the issue of diversity within a admissions program and how that is considered by the university, the court at the end of its decision, and I'll quote it, it says here that all parties agree that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so that takeaway for me as an attorney is easily translated to this personal narrative approach. As Dave said, you can't divorce yourself. I cannot divorce myself from the fact that I'm of Latino heritage and my parents are immigrants, that I was born in San Francisco, and that I'm a woman. I just can't divorce myself from that. My personal experience appropriately reflects those realities. So my advice to clients has been that is kind of a one area where the narrative, the individual can express themselves, bringing up their own experiences, as they've mentioned, whether they be by discrimination experiences or otherwise, based on race and sex. And I'll come back to that in a moment. The other reference in the IFR that when you've kind of drilled down borrows from some of the guidelines from the Small Business Administration that had a similar presumption in favor of race and gender, and then separately guidelines under Title VI. And these are guidelines by federal agencies. And again, I can send the citations to that by separate email. But at the end of the day, the personal narrative, as Dave said, has to be, in my opinion, specific. It has to avoid conclusions such as I'm disadvantaged because I'm a Latina kind of conclusion. It has to be as in-depth and concise as possible, which of course is hard to write. And you're not necessarily convincing anyone of your situation, but it's best to be complete. And to the extent that as Dave said, you can the individual can identify disadvantages, social disadvantages of the various categories: education, employment, business. That obviously is best, but obviously it doesn't have to be all categories, right? So at the end of the day, I think that speaking again as an attorney, and I mentioned this to Dave and the Keen Group, that the best way to consider this, if one is asking, this is what I tell clients, is tell me about your past experience, so past societal disadvantagedness that are having an impact in your life today. So the past, not discrimination, but it can be discrimination, but past disadvantages that the individual face that have present effects today. I think that's essentially the legal standard that I draw from this requirement. The only other thing I would add is that from a certifier standpoint, that the certifier cannot base his or her or its decision to certify based on race or sex. That's clear. That's clear from the Harvard case. That's clear from the IFR. That's clear from the law. But that's where the prohibition is. But happy to, this is a complex area of the IFR and of the law, so I'm happy to answer any questions that folks have later on.
Okay, and we promised time for questions. I will try to quickly go through the rest of this. There's another issue related to um, there's another issue related to the IF to the personal narratives, and that's how much of an arm's length does the certifier need to have with the DBE? Certainly, you can't write it for them. We are in our discussions around the country, and we've actually sent proposals to certifiers that have asked for them to provide the similar type of assistance to DBs in their state that we did in the pilot. Um, and they are interested in having somebody, either us or somebody like us, be able to solve the blank page problem and get something in a personal narrative that can be reviewable by that state. Um, Others have been more reluctant and they say, we have to stay away from this. And I wanted to point out in the IFR, that's not been the tradition under the federal DBE program of staying away and just being completely arm's length in certification. And in the IFR, there's an anticipation that there will be assistance and support services from certifying agencies to DBEs and ACDBEs that are going through the reevaluation process. So this is what's the language in the IFR that says, hey, we expect you all to spend time following up with applicants, that there will be support services from certifying agencies, directly or through contract that would be made available to DBEs. Now, certainly they didn't just send a bunch of money to do this, but the anticipation is this will happen. They also, in the IFR, say that they estimate 90% of current DBEs and ACDBEs will attempt to retain their certification. They will participate in this reevaluation process, and that 10% will drop out. Now, we think it's the other way around if there's no assistance. We think that 90% will drop out and 10% will attempt to retain certification. That was certainly our experience from the pilot. So, do we think this is a real danger and something for you all to be thinking about how and what way to help? Okay, that's not the only thing you need to do. Very quickly, you need to submit a new overall DBE goal. This is before your regular calendar of where you fall in the years that your goal is due. We don't know about those dates, but what we do know, as soon as the reevaluation is done, there's the anticipation that each entity operating the DBE program, that's a direct recipient that creates an overall goal now, would very quickly, as soon as practicable, submit a new overall DBE goal, counting DBEs in a different way. And it's the counting DBEs in a different way or ACDBEs in a different way that's really the only change. So the next slides are basically saying nothing has changed except for how you count DBEs. Now that's a big something. And going to the base figure, this is still a two-step process. Base figure, how you look at what you can rely on has not changed except for data from a disparity study. That disparity study must account for firm capacity. That means you're not counting small firms that can only do small projects as available for multi-million or billion-dollar projects. That's what capacity means to us. We have incorporated the concept of capacity over the last 20 years in our disparity studies. It's held up in court. So we have a way, all of our analyses account for firm capacity. In the industry, that's rare, and most of the studies that are out there do not, but we do at Keen Independent. But all these other things that are listed here are the same. We think a disparity study is a good idea because that's a way to get at potential DBEs. And you're not going to know about firms that could be certified as DBEs without talking to and doing availability surveys. So we have a survey in the field right now in Alaska that we've added a question to. We explain what DBE certification is. We're asking the respondent from a firm to be able to say, knowing that, do you think your firm would qualify and be interested in DBE certification? And we will be using that information to add to current DBEs or future DBEs that make it through the reevaluation process in Alaska, plus these potential DBEs that are not yet certified. Otherwise, the goals are going to be 1% and 2%. We think is because of the drop off in the number of DBEs that are certified, assuming that a lot of them will not come forward and go through the process. So that there's a lot of assumptions in my statement there. Hopefully, they don't come true, but in many instances, the goals are unrealistically low, and you're really not complying with the federal requirements to look at potential DBEs. That was always a part of the process, unless you're going out and collecting that information, which is now you can't just assume that a minority women-owned firm is a potential DBE because you don't know that, and that's not the way goals work anymore. Um, Step two adjustment, that's still in place, but the language has changed. We have a methodology to look at potential adjustments, basically saying if there were a level playing field for socially and economically disadvantaged individuals, what would your goal be? And that's a lot of the words on this page are right out of the old regulations. They did not change that much. And we had a methodology that we had to then adapt to be able to look at new step two adjustments. So you've got to do an overall DBE goal, and let's say it's spring of next year, but your goal isn't due until August of next year. Pre-October 3rd date would have been, pre-IFR, you would have been planning a goal, in summer of next year or summer of the following year. You need to have a goal right away as soon as you have the reevaluation done. And you need to update your DBE program plan. There's some technical things that need to be changed in that. We think this is going to be relatively straightforward, but you still need to project as part of your goal setting process, what's going to be neutral? What are you going to achieve through neutral? Is there anything left over that needs to be met through DBE conscious? And then your program plan needs to be updated to reflect that. So it's not just changing the words in the program plan, it's actually looking at what your new overall goal is, what the projections are, and then having the plan align with that. And both need to be submitted to your operating mode for their review. And then resume DBE contract goals as needed, which is the last box in our first slide that showed everything that needed to happen to get to this point. And at this point, it's remarkably the same. A firm is either certified as a DBE or not certified as a DBE. You can set DBE contract goals if you need to. Good faith effort stays in place. All the other tracking stays in place. Even if you don't have DBE contract goals, you're going to track. And we also have the recommendation of, in addition to DBE tracking, participation tracking, track participation of small businesses because you want to know how well your small business efforts are working, and minority and women-owned firms, both the certified and non-certified firms, because an entity's obligation to not be discriminatory based on race and gender of the business owner has not gone away with the IFR. And you may need this information in the future to be able to know what the impact of the IFR is on minority and women-owned firms, and potentially in the future, are there additional steps you need to make that you may need to make through a request for waiver? That was a big mouthful, Mara. What did I mess up? And then we'll get to
No,
Q&A.
no, spot on. Spot on.
Okay. Nikki, back to you.
All right, fantastic. So some of you have already figured this one out, but we have a Q&A function here that you can use. So that's at the bottom of your window on Zoom. You should see there's a Q&A, and you can type your question into there. and I will read the question aloud to the panel. So as a reminder, this session is recorded, and it will be posted to YouTube. So in order to keep everything anonymous, when I read the questions aloud, if there is any identifying information, your name or your agency, I will omit that as I say the question out loud. So you can also omit it in your question yourself. So fantastic. We have a few questions already teed up here. So I will start by reading those. So first question that we had that came through in the chat was, can you expand on continue neutral measures in DBE program plan? Neutral measures include counting neutral DBE participation.
Real
That
quick,
sounds like a Dave question.
yeah, well, and I'm going to pass the do you count neutral DBE participation tomorrow, but example of neutral measures would be um, uh, um, pre-bid sessions, outreach to small businesses. Some entities actually have approved small business contract goals programs. Ohio DOT, it would be an example of one that I believe even in advance of the IFR was getting off the ground. Um, there are others that probably wish they had approved a small business contract, SBE contract goals programs sitting here today that do not. And so the question would be, can you just do that even if it's not in your program plan? And I've asked Mara that question, so she can give you the answer. Plus, do you track neutral DBE participation?
Okay, so this is an interesting question on neutral measures in the DBE plan because from my lens, the DBE plans should be supported by a disparity study, and because it's just the safest path forward, notwithstanding the IFR. We can get into the answer a little deeper, but if you take the position as the Department of Justice and the DOT have taken that the program, the remedial provisions of the program that have been authorized by Congress cannot stand because the evidence is insufficient, then you're left with the requirement under law that you not only adopt race neutral measures, but that they be finely tuned to address the existing evidence of discrimination or disparate treatment or obstacles. And so when you take that kind of narrowly tailored lens with the race neutral measures, really, in my view, it goes beyond what the IFR or even Part 26 in its prior position was suggesting. So really, if you have a disparity study, you follow the race neutral measures that the disparity study has recommended under the framework of strict scrutiny. You narrowly tailored those race neutral measures basically to get to get to the issue that's being identified. And whether you can count it, from what I'm reading from, I don't have all the answers, by the way, but when I'm reading from the Q&A, that until the reevaluation is complete, and there's a question as what that means, you're not counting even race neutral measures in your DBE plan. But obviously, if you've gone through the process, then I would think so.
Thanks, Mara
But
and Dave. Okay, we've
No,
got,
next question.
yes, we've got about 6 more questions here. So the next question is, I am a certifying agency in a fairly large state. We have 9 certifying agencies throughout the state. Our state DOT office has not given us any guidance on how to proceed. In fact, they seem to be reticent about moving forward. Many of us are ready to at least move forward with the reevaluation of our currently certified firms. Can we certifiers in the state move forward with reevaluating firms without the state DOT moving forward?
Boy, that's a hard one. I pass. Mara?
Well, obviously, it would be best to collaborate with others in the state so that there's a uniform approach. I mean, that's, I think, just obvious, but I think the duty to move forward is on every grant recipient. So I think the answer would be yes. You have to do your due diligence. Uh, yes.
All right, thanks, Mara. Next question was the slide deck, and I can answer that. We will be sharing a YouTube link following this presentation once this is uploaded, and the YouTube link, of course, includes the entire PowerPoint. Next question is, will the FAA change the due date of the triannual DBE and ACDBE programs and goals?
Our reading of this is we don't know. However, it would seem that if you have a goal that's due now, you're told to ignore that deadline and to submit a new goal using the new information about DBEs and a new way of calculating the overall goal for DBEs or ACDBEs. Once the reevaluation of DBEs or ACDBEs is complete in your state. So ignore what we're hearing is, and what we're reading is ignore all deadlines except for the one that says do this as quickly as practicable, and then you may get onto the next sequence of every 3 years, submit your goal. But I don't have an answer to what that future process is going to be. If they're going to reset those, does it make sense? We just talked with a past client yesterday that has a goal due in August of 2026, but they may need to, or they hope to be able to submit their new overall goal much earlier than that after the reevaluation. What do they do in August of 2026? Well, it might be just the same goal or slightly updated, might be the answer. Or maybe that August 2026 date is changed by USDOT, and there's more information about that. I think that answers the question, but Nikki, poke me if it doesn't.
Nope, that sounded pretty good to me. Yep, if there's follow-ups needed, then please let us know. Great. So, next question is a disparity report now required with the new IFR?
We have a slide for that, if I can get back to it. So the language about how a base figure is developed mentions disparity studies and has the caveat that it's got to look at firm capacity, which we do. But it did not change the other methods. Now, some of these other methods just might not work as well, like the bidders list, because you might not, how do you count DBEs on your bidders list? It's certainly not the old data on who was a DBE at the time, say a bidders list for 2 years ago. So they didn't change it, but we have questions about how applicable and practicable that approach is. Um, we also have questions about using the goal of another DOT recipient. We have questions about that anyway. But you have to make a bunch of adjustments, and making those adjustments is even harder now. So you're left with the DBE directories, which we think are going to be hollowed out, and we have that concern anyway, and data from a disparity study that has the ability to look at potential DBEs. So we think that's your best option, but they didn't change the language and remove the other four options. And then there's the fifth option, which is anything else you can come up with, alternative methods. Mara, did I get that right?
Yes, and the only caveat would be that in the Ninth Circuit, under the Western States case, I think disparity studies are really the only way to go. But my preference as a practitioner is that there be a disparity study. It's just a better tool to get at all the issues, including race neutral measures that are more precise in moving the needle, if you will, in addressing what is discrimination based on race and gender.
Thank you, Mara and Dave. We do still have a few more questions, so just being respectful of folks' time, we'll answer these few more that we have, and we might adjourn a few minutes after the hour. So thank you. Appreciate you all being here and being patient and coming with questions. Our next question is, there is a lot of focus on the firms and PMs, and rightfully so. However, how or what assistance is there for certifiers relative to the ability to objectively and clearly articulate the rationale for decisions where the firm has not met the burden beyond just reiterating what is in the IFR? Why did it not meet the criteria in the IFR?
So you should have had a process for this because at any point a white male owned firm before October 3rd could have applied for certification. And so and there was in the 2024 final rule outlined a process for how to consider those types of firms. So it's not that we have nothing about this. We've actually had this opportunity or potential applicant in every state for decades. And what the process is for considering that application and what to look for, the USDOT has changed over time, but most recently in the 2024 rule, explained what they were looking for. Uh, so the other question here is how much can you rely on the Small Business Administration process for considering 8.8 applications um, after they were getting negative outcomes in some litigation around the race and gender conscious presumption that they had been making for 8A firms before. So they were ahead of where the USDOT is. And so they had a process internally. So it wasn't states doing that, it was the Small Business Administration. They were looking at factors that were certainly similar and were able to work through and then make a determination, document that determination. And then finally, we keep going back to the city of New Orleans, but they've been doing this for a while. And talking with the people there, I just talked with somebody again in the last few days about what did their documentation look like. They actually had formal documentation from the applications. The certifier, the staff person had to do that and would write down what they considered in making a positive certification decision, and then probably more extensively a negative certification decision because those decisions could be appealed. In the reevaluation, one of the important points that we didn't mention is there is no appeal to this UCP in the state of a denial of certification, but you can still appeal as a DBE that's not been favorably reevaluated. You can make an appeal to USDOT. Um, so, not knowing what process you had in place in the past, um, you should have had a process, or that would have been ideal in following a consistent process in the future about making certification positive or negative decisions on this. There's also the question about do you go back and ask DBEs for more information as part of the reevaluation process? And we expect, frankly, different states are going to end up in different places about that, in part because of just based on volume and how much staff time they have and how quickly they're trying to move. So that's probably a very long non-answer. Mara, you can give a clearer answer if you can.
Uh, frankly, I haven't ever handled a socially and economically disadvantaged application under the prior law that did not include race and gender classifications. So I'm a bit of a loss. What I would be, unfortunately, I think it would be more of a case by case kind of situation because the personal narrative approach is case by case. Um, but yeah, I'm sorry to not be able to give guidance. I'd have to give it a little thought.
Yeah, and you would agree that documentation of your decision is very important here
Absolutely. Yeah.
because depending on how you decide, somebody could appeal to USDOT, and that documentation could become very important.
Yeah.
And USDOT could come in and review the process, the overall process of reevaluation, and you wouldn't want to be left with, how do we make these decisions? Well, we just did it this way, and we don't have anything in writing about how we were supposed to do it and how we ended up doing it. Again, another quick bit of advice is follow what it says in the IFR. Did they talk about the types of disadvantages that were anticipated? Did they do that with some specificity? It's Mara, correct me if I'm wrong, but it's a preponderance of the evidence standard. You do not need to, prove beyond a reasonable doubt that you have been socially disadvantaged. Is what a reasonable person might interpret based on what you have provided on the page. And so you can't take other things that you know about that firm you have to be careful to not take that into account and not, really write their personal narrative for them in a way as you're doing the interpretation and review. It has to be what they submit, not what you might know about them in other conversations or observed about them. This is really a blank sheet as far as you're concerned in terms of making a certification decision. And the fact that they're a minority or women-owned firm should not factor into it. Um, uh, your knowledge of that, it should be about what they put on the page. If they've experienced just different types of disadvantage or including race or gender discrimination that they describe in sufficient detail.
Yeah, and again, I would remind folks that from my lens, the past is important, but it's also connecting the dots between the past experiences of disadvantage to the present time. So what we call in the law the present effects of past disadvantage or discrimination. So the party should explain that, connecting the dots, rather than
And,
speaking about things that happened maybe 10, 20, 30, 40 years ago.
And if they haven't done that, then depending
That
on the
would be,
rules that you've set up, you might not be able to certify them, even though they've shown some social disadvantage. The IFR doesn't say it's social disadvantage alone. They talk about this connection. Okay, Nikki, next
Yep.
questions.
Thanks, David. And I just want to note we did have a couple of comments that I'm going to skip over about how folks are doing this currently, just in the interest of time. So we have three more questions. This one was kind of related to what you were just talking about, but if you had any additional comments, I'll read this one out. The legal advice we, a certifying agency, are getting is that we should not accept any personal narratives that include even reference to a person's race or sex, going as far as saying single parent versus single mom, for example. We don't agree with this path and would appreciate any additional information around this and how to push back in alignment with what was discussed today.
My short answer is talk with Mara after this meeting, retain her. We think that as a non-attorney, I'll go ahead and give my non-legal opinion. You might face um, potential legal risks if you prohibit people from doing that because you really are then discriminating based on a particular person's race or their gender. Mara, you think that's fair? They should call you after this?
sure. But again, as I repeated before, and I'm happy to give the citation on the Harvard case. When you read the IFR, they're citing Harvard as essentially the case that they're being guided by because it is the United States Supreme Court case. The other cases that they're citing in the IFR do not have national application. And I've read earlier in this presentation what the United States Supreme Court had to say about, a personal narrative approach in the university context, but essentially that fits here. And so I disagree with the position that you cannot mention race or sex at all when that defies the reality of the individual.
Hi,
Thank
talk
you.
tomorrow afterwards.
Yes, exactly. This question is, what about new applications? Can we accept new applications? USDOT has not created a new application. The current one accepts ethnicity and sex as an identifier of disadvantaged status.
Mara,
I
I
would
don't see
say,
how you can't accept a
yeah,
new application.
not yet.
Um, Not yet. Okay.
Not yet.
I would
Okay.
say that it's best to have your process, your reevaluation process in place, get your ducks lined up, see if there's additional Q&A guidance coming out of the DOT as a result of the comment period. Ask questions directly of the DOT. They're supposedly waiting by the phone to help the folks out. That would be interesting to see if that's the case, but I would not move to new certifications immediately until you understand what your process is and how to move forward, because then it just gets very disruptive.
What
Uh,
you don't want to do is undo a certification that you are making now when you really, you don't have to, but you will need to get this new certification process up and running, or else you're not treating firms, a white male-owned firm that is not now a DBE. There may be an argument that you're really treating that new applicant differently than a current DBE that was certified under the old system. Nikki, would you have an additional question?
Yes, final question here is our current DBE program and goals are race and gender neutral. I need to reread the IFR, but I'm not getting the impression that we will need to change much. Is that the impression that you also get?
uh, you are in the same boat as somebody that has a race and gender based program. You need to reevaluate DBEs. If you're an uncertified agency, you need to, wait around until that reevaluation is done. Then you can start, and I'll go back to that slide. And which is, we started there. It's a good place to end. You need to do all the boxes. So you need to notify DBEs. You need to prepare for recertification. If you're a certifying agency, that reevaluation needs to happen. You need a new overall DBE goal, whether you're a neutral, operating neutral or not. And you need to do that projection again. Maybe it will turn out the same, that you'll still be DBE neutral using the new terms in the future, and you need to submit a new DBE program plan. If you do not do that, you're not compliant. So you're not necessarily heading towards restarting DBE contract goals, but you don't know until you've done all of this. You can't make that assumption. And then you will also restart counting DBE participation, even if it's under entirely neutral program.
Okay, thanks, Dave. Sorry, we had one more quick question that popped in, and this will be the last one. Who will be approving the new DBE personal narratives?
I think that's the certifier that will be considering the new DBE personal narratives.
So thank you again very much for attending. Thank you for being engaged. Thank you for your questions. We understand this is challenging to navigate, and appreciate you all being here. We are available for follow-ups as well. Thank you, Dave and Mara, for all of that information. Really appreciate you all.
Thanks, everybody who attended.
Thank you.